My name's Matt Gingell. I'm an employment lawyer and a legal commentator. My practice is mainly based in London. I've got the dry slot talking about the law, but please try and stay awake if you can. The law's fairly important. So I'm going to talk about employers' responsibilities when it comes to mental health and potential claims that employees could bring. I'm not going to have a chance to talk about all the various claims in a huge amount of detail, but I'm going to flag up some key areas to think about. The first area is health and safety at work and the health and safety at work legislation. Under the Health and Safety Act 1974, employers have a general duty to ensure that wherever practically possible, employers are able to ensure that employees at work have a healthy, safe working environment. There's also, under associated regulations, requirements for risk assessments to be carried out. And these risk assessments could include assessments about stress levels, about workload, and whether employees are coping. So it's important to see the health and safety legislation and the regulations as much as about mental health as well as physical health at work. It's important to stress that the health and safety legislation imposes criminal liability. There could be fines for breaches up to, I think, £20,000, and there can be unlimited fines and even imprisonment where there are deliberate breaches of the legislation. The legislation and regulations are enforced by the Health and Safety Executive and also local environmental officers. So that's the first area to consider. The second area is unfair dismissal and the law of unfair dismissal. Employers can dismiss fairly, but they have to have a fair reason for dismissal and they have to follow a fair process. And employees generally who have 2 years service or more can bring unfair dismissal claims. So one of the fair reasons to dismiss is capability, and it could be capability on ill health grounds. Where someone is not capable of working, there's a potential fair reason there for an employer to dismiss. But an employer does have to follow a fair process, and each case is going to depend on its own circumstances. But some of the things that employers would need to consider would be whether there were sufficient warnings that had been given, whether medical evidence at the time had been gained before any decision to end employment, whether the employee had an opportunity to put forward their case, whether there were alternatives to ending the employment. So that's capability. There's also misconduct. Misconduct can be a fair reason to dismiss. There was a case a few years ago where someone was suffering from schizophrenia and they didn't take their medication on the advice of a doctor, and then after that they sexually assaulted 2 women at work, and the employer dismissed the employee on the basis of gross misconduct, and the court held that in fact the dismissal was unfair because the employer hadn't carefully considered whether the employee was culpable and aware of their actions. So there are times where employers have to balance the interests of other employees, where the actions of people who are suffering from mental health illnesses can affect others, but also have to consider those individuals as well. There is then also what's called constructive unfair dismissal that some of you may well be aware of. And employers have implied duties such as the implied duty of trust and confidence, the duty to ensure a safe working environment. So where there are cases, for example, where employers are bullying or harassing employees, or, for example, employers are giving employees a huge amount of excessive workload, employees who have the 2-year service can consider, in certain cases, resigning and claiming what's called constructive unfair dismissal. For unfair dismissal, there is a cap of just under 84,000, so there's a cap on unfair dismissal claims. So that's the second area. The third area, which I want to flag up, is disability discrimination. Now, people who are suffering from mental health conditions may well come within the disability provisions, but again, each case is going to depend on the situation. To come within the disability provisions, an employee must have a physical or mental impairment which is substantial and long-term, and has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. So normal day-to-day activities could be concentrating, for example, engaging. Someone, for example, with depression may not be able to concentrate properly. Each case is, again, going to depend on the circumstances. Interestingly, Theresa May, in the last manifesto, said that intermittent absences are going to be considered, and then there will be consideration for changing the equality provisions for intermittent absences. Unfortunately, Brexit has paid stop to a lot of considerations on other issues, so we don't know yet whether there are going to be changes on that particular topic. Where disability provisions do kick in, employers mustn't discriminate in a number of ways. One of those is that employers mustn't treat employees less favourably because of a disability. They mustn't treat employees less favourably as a result of something relating to a disability. And there is also a duty, for example, to make reasonable adjustments to make sure that employees are not disadvantaged in the workplace. Now again, when we're looking at reasonable adjustments, it will very much depend on the circumstances. But it meant when people are suffering from mental health illnesses, some of the reasonable adjustments may be, for example, changing the performance targets for that individual. For example, considering whether duties can be changed, whether hours can be changed, whether there needs to be a risk assessment, whether there needs to be time off for treatment. So those are just a few examples, but employers would need to consider reasonable adjustments. And then finally, there is an area of what's called stress claims, negligence. Employers have a duty to make sure that employees there is a safe working environment for employees. And in certain cases, if that is breached, for example, there's harassment or bullying or excessive workloads, and an employee suffers personal injury, such as psychiatric injury, an employee could consider bringing a negligence claim. Now, these claims are very difficult to bring, primarily because the employee needs to show that the injury, the type of injury, is foreseeable. And usually the cases which are successful are those where there has already been, for example, a breakdown, and an employer has a red flag, and then continues despite that, for example, to give the employee excessive work. But these cases are continuing to be heard, and it is obviously an area that employers need to be aware of. I just finish by saying that irrespective of the law, irrespective of all the requirements on employers, there are plenty of other reasons why employers should take mental health at work seriously. And just to name but a few, for productivity, for retention, and for reputation, employers need to take mental health at work very seriously. Thank you.